We have the case law update. And this is a 1 hour session. Rebecca Garcia, the vice president of the association, is the moderator. So I'll turn it over to her and her group.
Thank you. Hopefully, everybody enjoyed that session from the UST. I think we received a lot of valuable information. I'm just going to start by we'll get right into this. As we've already talked about, Chapter 12, there's not many cases being filed. So our case law update, we've got some good cases, but there aren't that many of them. So just to get started with me today, we have Judge Jeffery Graham. Judge Graham was appointed to the bench for the Southern District of Indiana in 2014, and he became chief judge in 2021. He's in Joe Black's district. And then I know that from Joe Black and from hearing Judge Graham speak to us back in Indianapolis in 2016, that he grew up on a farm, as I did. So for those of you who are farm kids at heart, hopefully we'll bring some of that perspective if we can. And then our other panelist today is the hardest working panelist, I think, of the day, Karen Jolley. Karen Jolley is Kara West's staff attorney. Karen has combed through all the cases and prepared all the materials that you have in front of you for the case law update. So special thanks to Karen for all her hard work on this. And I think we'll just get started. And the first case, I believe, belongs to Karen, the Ruiz case.
That's right. And are we able to pull up our PowerPoint?
Oh, yes, I have it ready. Hang on, give me 1 second.
You are. I have it shared.
This might just be kind of a helpful guide as we're moving through the materials.
New share.
And as we go, we're going to be referencing the items, the summaries as they appear in the case law update. It might be easiest just for us to list that number rather than the specific page, just since it's part of the larger materials.
And Karen, go ahead. I'm just going to work on sharing this. Maybe Courtney, you can message me offline while I work on this.
Okay, sure. So the first case we'll discuss is Henry Ruiz, and it's in your materials at number 1 and 4. This is an opinion from the U.S. Court of Appeals for the First Circuit, and it deals with the police powers exception to the automatic stay. As you probably did not guess when I said police powers, this is actually a case about milk quotas. So first, a quick summary. The basic facts here are that the government agency in Puerto Rico that regulates milk production and distribution revoked a bankruptcy debtor's dairy license and ordered him to sell his milk production quota rights. When he didn't do this, the agency attempted a public auction of the quota. Both the bankruptcy court and later the district court found that planning that auction violated the stay. However, the First Circuit reversed, stating that the auction falls squarely within the police power exception under 362b4. As a quick aside, it's relevant to know here what this particular agency does. The First Circuit describes that the agency grants dairy farmers licenses to operate. They also determine the amount of milk produced in the market, police the standards and quality of milk throughout the supply chain, and allocate milk quotas to licensed farmers. Those milk quotas can be sold, leased, or used as collateral by licensed dairy farmers. All right, so now back to the case. The debtor here filed for Chapter 12 bankruptcy in 2015. Sometime after, the agency investigated his milk production and found evidence of milk trafficking. Milk trafficking is described in the opinion as when a farmer either sells raw milk that the farmer did not specifically produce or has lied about the amount of milk produced. In response to finding milk trafficking, the agency sent the debtor a notice of complaint that threatened to revoke his dairy license. Then a few months later, the agency actually issued an administrative decision that revoked his license. In the decision, the agency ordered the debtor to dispose of his milk quota through a public auction within 60 days. Rather than doing that, he appealed. That appeal ended in May of 2020 when the Puerto Rico Supreme Court issued a final decision denying reconsideration of the agency's decision. But still, the debtor did not sell his milk quota. In response, the agency issued a notice to publicly auction the quota. Before the scheduled date of the auction, the debtor filed an adversary proceeding against the agency. In the adversary, the debtor alleged that the agency knowingly violated the automatic stay by taking steps to auction the quota without the bankruptcy court's permission. The bankruptcy court enjoined the agency from conducting the auction without court permission and eventually found that it had violated the stay by taking steps to auction the milk quota. The bankruptcy court left open the issue of damages. The agency pursued an interlocutory appeal to the district court, and in that appeal, the district court agreed with the bankruptcy court that the agency had violated the stay and that the police power exception did not apply. In affirming, they returned the adversary to the bankruptcy court to decide damages. The agency then appealed to the First Circuit. So the First Circuit first had to analyze whether it actually could exercise appellate jurisdiction under 28 U.S.C. section 158d1 when the district court had affirmed the bankruptcy court's order and also returned that adversary to the bankruptcy court to decide damages. The First Circuit explained a district court's order in adversary proceedings is not appealable as of right under section 158d unless it ends the entire adversary proceeding on the merits and leaves nothing for the court to do but enter the judgment. But the court then went on to distinguish a private creditor accused of violating the automatic stay from the important governmental interests that are protected by the police power exception, which are at issue here. It found that it had jurisdiction because the lower court's denial of the agency's motion for summary judgment based on the police power exception are final decisions appealable under the collateral order doctrine. So now turning to whether the police power exception is applicable, the court established that the milk quota at issue was property of the estate, that although the automatic stay is broad, the police power exception to the stay ensures the government agencies can still enforce laws that affect the health, welfare, morals, and safety, and that debtors are not automatically protected in bankruptcy from those regulatory laws. Considering the statutory text of Section 362b4, the court found that the revocation of the debtor's dairy license was certainly a proceeding by a governmental unit to enforce its police and regulatory power over milk safety and marketing. By its terms, the police power exception applies to the enforcement of a judgment other than a money judgment obtained in an action or proceeding by a governmental unit to enforce its police or regulatory power. The court saw that this auction was a step in the enforcement of a judgment revoking the debtor's dairy license that would not produce a money judgment. And for that reason, the court saw the undisputed facts show that the purpose of the agency's action was to protect public safety and welfare. So because of that, the planned auction of the milk quota did not violate the automatic stay. So now when you hear about police power exceptions, always think of milk quotas.
Thanks, Karen. I guess next we'll turn to Judge Graham, and he is going to talk about a case that's dealing with attorney's fees.
Sure. I mean, it's always difficult as a bankruptcy judge to follow one where the appellate court overrules and reverses the bankruptcy court. So with a tear in my eye, I'll go forward. But Henry K-Bar A Ranch, from the facts of it, was basically a fairly nondescript Chapter 12. Basically, one large creditor, the bank, and then they go through, the debtor puts together a plan. There's some going back and forth, but eventually they're largely agreed on most of the terms. But there's a sticking point, which is the creditor really wanted a, quote, status quo provision that provided each covenant term and obligation in the pre-petition agreements would not be changed absent express modification in the plan. Some may wonder, is that even a necessary provision? But that was the sticking point largely in this Chapter 12. They went through a couple different agreements. Each time the creditor says, I want my status quo agreement. The debtor declined respectfully, but eventually they did come to conclusion. The plan was confirmed and all is well. And that's until the creditor's law firm files an application for compensation. And generally speaking, you would think in this, where there's no contested hearing in the bankruptcy, just a couple meetings and agreements and meetings of the trustee, the creditor's attorney filed a fee application seeking $49,767 in fees and a whopping $6.70 in expenses. And then the court as soon as the court starts writing its opinion, you know where it's going, because the court complains about the tedious work that it has to do in reviewing the Chapter 12 creditor counsel's application, but they were going to go ahead and do it anyway. So here's some detailed and some interesting tidbits of what not to do as creditor's counsel attorney in this case. So here the creditor was not just oversecured, it was oversecured by 233%. So even going into the bankruptcy, it had a significant equity cushion and likely would come out whole no matter what happened. Debtor's counsel and its application for employment or for a compensation billed 60 hours. Creditors counsel billed 152 hours. So right there you have a disparity between what the debtor did, which generally would have more hours in as counsel, versus the creditor's attorney. So the fees sought here were under 506B, just 4 things you have to look at. One, does the creditor have an allowed secured claim? Here it did. Is the creditor oversecured? Here it was. Are the fees reasonable? Well, that's going to be fun to discuss. And then last, are the fees allowed under contract? And they were. So this whole case revolves around reasonable. And the court goes through, we had our trustee, a U.S. trustee office representatives on earlier. And if you've ever done an application, either in 11 or 12, you know that there's a few things they set out that they want you to do. One, you have to put detail in the fee application. One is you cannot lump. I worked as a Chapter 11 debtors counsel in my previous world. And if you didn't know about lumping in your first week, you would know about it whenever you first did it. But you have to task base and set them apart. You can't just say, I worked for 3 hours on plan issues. You have to put it out. But these were not necessarily seasoned Chapter 12 attorneys. And more importantly, they weren't seasoned Chapter 12 attorneys in the District of Montana where the case took place. So those were 2 things that would come to haunt them as they went on. But they lumped all of their fees. They didn't put detail in. They actually didn't even put a breakdown in their fee application until the initial hearing where the judge asked for it, and they came back and did it after that. But long story short is these fees were roughly 2 to 3 times higher than similar cases. There were no unique issues in the case. And that there really weren't any novel or complex objections to the plan. And because of that, and the court goes through and highlights some instances where they thought they were fee, but then they did every bankruptcy court's favorite thing. They just lopped and came with a amount, which here was $12,500, which is well on $30,000 less than what they sought. So the takeaway here is know where you're practicing or where you're putting for fees, because the judge really relied on similar cases in its district. And secondly, the biggest thing here was the creditor was really trying to charge for educating their client on what Chapter 12 meant and to what all the Chapter 12 terms meant, which as an attorney, you can bill your client for that, but don't seek application for that because that will draw a judge's ire. And that was largely the reason that the court thought it was not necessary and allowed a whopping sum of $12,500 rather than the $49,000 succeeded. You will be happy to know the $6.70 reimbursement of expenses was allowed in toto. So they at least got through with that. But that's just a cautionary tale for attorneys practicing a creditor committee, but also gives you a rule of thumb that some courts will generally look at what they've allowed in similar cases or in recent cases is what they believe to be reasonable.
Sounds good. Well, I'm up next, and this is a case that I think we all need to pay some attention to, sanctions and stay violations. So the headline of this case that I wrote down is that the court found that the creditor's attorney, the debtor's attorney, and the trustee violated the stay and sanctioned $105,000 that they were joint and severally liable for. So I hope that got all of your attention right off the bat. I will go kind of through the cases here. So this was a case that was confirmed in 2020. The confirmation order provided that the debtor shall not buy, sell, use, lease, or encumber property without or otherwise dispose of any interest in any real property or personal property with a value of more than $10,000 outside the ordinary course. And I think it becomes important that that was in the confirmation order or in the plan without notice in a hearing. And the other thing, this plan also provided that the property of the estate revested in the debtor upon completion of payments. So that, keep those two things in mind. So this debtor was a dairy farmer. During the course of the case, it became apparent to the parties, including the debtor, that, you know, it just wasn't working, and there was decisions and emails made between the creditor's attorney, the debtor's attorney, and the trustee that, you know, a sale needed to happen here. And as this case wound through the court, the bankruptcy court, a lot of these emails came out, and there were discussions in the emails that went back and forth of, oh, we need to get court approval for this, or, you know, we need to get the auctioneer hired, but none of that actually happened. So during the course of the case, without court approval, the milking herd was auctioned off, farm equipment was auctioned off with multiple sales. There was never a motion to sell. There was never a motion for relief from stay. There's no other orders. And the trustee and the creditors knew that this was all going on, but the court didn't. And the court found out. So this happened, you know, the case was in 2019 case, confirmed in 2020. This happened during like 2022, 2023 was when all these sales happened. In June of 2023, the plan was modified, and it reduced the unsecured creditors from about $83,000 to zero. So that reduction from 83 to zero, and whatever language that was put in the plan made it very clear to the court that a lot of stuff had been sold and nothing had happened about it. And so the court set a hearing, and they, you know, there were, like I said, a couple hearings. At first, the creditors and the trustee were like, oh, these were emergencies, they had to happen. And it turned out they really weren't. I mean, they needed to maybe happen relatively quickly, but there was certainly time to file a motion, and you know, go through the regular process of selling the property. And as the court went through the, you know, and there just, you know, kind of some excuses that came up, and they just, none of them flew. And I do encourage you to go and read the case, but the bottom line analysis after the court went through this, and she eventually basically did an order to show cause, but one of the things that the creditor argued was the creditor's argument was that, hey, the debtor consented to all this, so it really doesn't matter. No harm, no foul. And the judge said, no, that's not true. The automatic stay does protect the debtor, but it protects the property of the estate. And it's designed to protect the unsecured creditors too. And the unsecured creditors who were harmed by this were the unsecured creditors without notice. The court also cited a case that said the debtor may not waive the automatic stay. So, you know, the court went through all this. You know, the parties had to, you know, file a lot of stuff. In the end, the parties basically admitted, yep, yeah, the stay was violated. They had come up with kind of a settlement. They didn't want joint and severally liable. They didn't get that. The judge sanctioned them, said it's up to you how you come up with this money, but you're all responsible for it. And as I was reading this case, and I was going through those 2 points that I mentioned before, the fact that there was language in the plan that prevented the debtor from shall not buy, sell, or lease, and the fact that the vesting of the property estate didn't happen until completion of the plan, would not happen in my district. And I'm in the Seventh Circuit. We have a case called Cherry. And I asked Judge Graham, and I said, hey, be prepared to answer this question. How would this be different, especially if the case was all that property vested in the debtor at confirmation?
Well, and I think that's the key here, because when the property of the state doesn't vest, it's still all in front of the bankruptcy judge. And technically anything should be happening. And there's the express provisions in the plan that also you're violating the plan as well. So it's kind of a double whammy. um, for the debtors and all the people here, simply because had they asked, I'm sure they probably would have gotten authority. They could have said it's failing, we're not going to be able to do it. But the important thing is you have to get permission, mainly because there's unsecured creditors who think they're going to get something and end up with nothing. And there's nothing for them to look to. Whereas at least if you put it in court, then you can make your arguments then. So I think it would have had a drastically different outcome. And frankly, as a judge, I do like things not vesting until the end of the plan, because you do want to at least have, if something happens, to have them come in front of you so you know what's going on. So you don't have someone come in later and say some weird motion in front of you from a creditor saying, Judge, they sold everything. And you kind of look like, well, how could that happen? Which I think is, I don't know, but I suspect is one of the reasons the judge was less than pleased with what happened and levied such a significant sanction.
And I agree. And I will say I've, experienced, it comes here in the Eastern District of Wisconsin, because of that Cherry case, our judges have basically said, yeah, you have to follow Cherry, which says it doesn't prevent people from vesting at some other point than confirmation. But what Cherry says is you have to have kind of a case specific reason for it. So, people are kind of encouraged. It happens less in 13s, but in the 12s, I say, well, really think about before you propose a plan. And the debtor has the ability to propose this plan, but how I would think about this and how I would say, you still got to get the auctioneer appointed, right? So the judge is going to know, hey, if you're appointing the auctioneer, there's other ways, in my view, it's not going to be a motion for a sale because the property has vested, but it's going to be to appoint the auctioneer. There's hopefully going to be some plan language. That language about, so doing stuff in the ordinary course of business, but not over $10,000 is common in the plans that I see. And so we make sure to get it in front of the court one way or the other. And I think that's really the bottom line to this case. You have to make sure that you keep the judge in the loop. And how do you keep the judge in the loop? You file a motion or you ask for it. And I agree with Judge Graham that had that been done in this case, we wouldn't be seeing this large sanction. And and for my trustee friends out there, if you know about this stuff going on, get it in front of the court, even if the other parties aren't. You don't want to be part of the group that gets sanctioned. So with that, we're going to move on. To bad faith, and this is back to Judge Graham.
Yes. This case, the Henry Bootjack Dairy M&D LLC, this is out of Idaho. This case largely embodies a lot of the difficulties that as you see as a judge with farmer debtors, and also just how they put some deals together, because as you read through this, one of the problems is you don't really see attorney mentioned until the end. You see title companies and closing agents mentioned, but the poor attorney doesn't get mentioned till the end. And I think that would have saved a lot of problems here. But here we have, and it looks like a second generation of farmers, at least second generation, at least not the main, where you had the original Bootjack Dairy, which was the parents, and they owned a lot of the assets. And then you had, it looked like two sons kind of created their own. And they're farming, but apparently there were some droughts and things like that, and their hay wasn't there, and they just weren't clearing as much money as they wanted to. So they looked, hey, let's sell some of our assets. And so they go ahead and do that, and they enter into an agreement with Black Butte for a sale and purchase of land, cattle, and other items. Other items including some Dairy Farmers of America rights and things like that. But they didn't use an attorney. So they're just kind of hammering things out and talking, but not talking a lot. But Bootjack came forward, or Black Butte came forward and did that. The deal gets extended multiple times. There's multiple addendums and agreements going on. But the relationship began to sour because they thought they were dealing with Black Butte, but they really weren't. Black Butte was a local farmer who yeah, I don't know if he created the entity specifically for this or was just another one of his entities. But long story short is they were assigning everything. The milk rights, other things, they were assigning those. But there also was a lot of agreements, despite the multiple addendums and everything else, where nobody really knew what was doing. One of the key issues here was when it came to harvest time for hay, Bujak didn't know who was supposed to do it. They thought that the buyer was supposed to be doing it. Buyer didn't. So they went ahead and harvested to a tune of 300 and some thousand and sent Black Butte the bill. Black Butte's like, what are you doing? So despite the fact that this was a multi-million-dollar transaction, nobody really understood what the other obligations were. So this started going forward. Finally, an attorney got involved, went to it and sent a letter to Black Butte saying, we think you've breached this multiple times. So if you want to sue us for specific performance, go ahead, but we're not doing anything else. Not surprisingly, Black Butte sues for specific informants in state court. Things don't go so well for the debtors there because of the multiple agreements that were signed. And ultimately, the state court kind of does a status quo thing, which essentially says, debtors, you needed to close this. You agreed to it. You need to close the agreement. But before the order really could be memorialized, the debtors thought, hey, Chapter 12 is our way to do it. So they file a Chapter 12. And the bankruptcy court is faced then with a motion to dismiss for bad faith by Black Butte. And they bring a lot of these things basically saying this debtor doesn't deserve to be in a Chapter 12. And this is a big deal now in Chapter 11's, which is who really deserves to be a debtor under the bankruptcy code. Because one of the main things here was the debtors had significantly more assets than liabilities. 6.5 million in assets, 3.9 million in liabilities outside of the Black Butte the transaction here where they're trying to sell off. So Black Butte says, Judge, they shouldn't even be in Chapter 12. They shouldn't be a debtor under the bankruptcy code. There's no need for reorganization. They have healthy operations. They have positive cash flow. They have no significant or substantial financial pressure. They have large reserves. And essentially, Judge, this is a two-party dispute. And they only filed this case as a litigation tactic, which, as an aside, every bankruptcy is filed as a litigation tactic. But specifically here, the only reason they filed, Judge, was because they didn't like the deal they struck and they weren't winning in state court, so they want you to undo it. The debtors, of course, counter, no. This was filed in good faith. We are in financial straits. The preliminary injunction, essentially, that the state court was doing was really affecting operations. And one of my favorites was just, we filed this to become better operators, Judge, and we're really doing well by filing. And this is helping us really right size and equalize our operations, which, keep in mind, we're profitable. So the court analyzes this under 1208C. And the fun part of this, because, yes, you can be dismissed for bad faith. There is no definition of bad faith. So it's almost always done by a case-by-case basis. Here they go through several multi-factor tests that go through what is good faith or what is bad faith. But essentially the court here boils it down to a couple things, which is this was not filed in good faith, it holds. Because of this, the debtors were in secure financial shape. Black Butte was seeking specific performance. And here, the biggest thing is the debtors could pay and wouldn't affect their ability to maintain other operations. There were no really significant unsecured creditors. The only unsecured creditors were largely created by the debtor in between the preliminary injunction and state court and filing, where they didn't pay some of their bills and created some creditors. The impact of the preliminary injunction, the debtors failed to show that it would have any adverse effect. And the court agreed that this was a private two-party dispute that could easily be resolved and was being resolved in the state court prior to filing bankruptcy. So the case was ultimately dismissed. And I really like this case because until recently, courts didn't really dig into that and parties didn't raise the issues of why you should be in bankruptcy. Not just, is it bad faith for the listed reasons, but The idea is that nothing in the bankruptcy would really affect the debtors. And here that was the case. You see it in the mass tort cases all the time now, which I had the privilege slash curse of being involved in. But when you start digging into who should be a debtor and why, the bankruptcy code doesn't have financial issues as a requirement. There is no statement that says you have to be in financial distress to file. But so much of it comes down to the fact is that if the bankruptcy doesn't really affect the debtor and they're able to operate, even with these obligations and issues, courts are starting to now say you don't belong in bankruptcy. It's limited jurisdiction and you can resolve this problem elsewhere. Here, that elsewhere was the state court proceeding that was already proceeding. So it's something that it's a cautionary tale. One is that I think farmers always have attorneys come in too late. But the cautionary tale here, I think, is we like Chapter 12s. We're glad when they're filed, but we have to make sure that there's a reason for filing it because it could go out pretty quickly. And as debtors counsel, and really any counsel involved in it, you need to look at whether or not this really does belong in bankruptcy. I mean, the two-party disputes always, usually that was single asset cases. You would see that in bankruptcy, whether there was a two-party dispute. But here it really was because Ag West, I think Ag West was the secure creditor. They were paid either way. They didn't care. They were happy. So it really was the debtors trying to get out of the bad deal that they struck, which honestly, from reading the cases, I have no idea when they said times were tough because ultimately their cash flow was good. Everything was good. I'm not sure these debtors really, as kids of the main operating company, understood what bad was. I think they just made less money and they got nervous. And boy, did they get whipsawed. So that's bad faith. But essentially, you have to look at I think the key is the entity does have to have a reason for being in bankruptcy. And here there was none. And most courts will kick it out if there isn't.
Thanks, Judge. The next couple are yours as well. And we're staying on the bad faith theme.
All right. Well, keep in mind, you will hear from Rebecca and Karen. So don't just hang up if you're tired of hearing of me. I also want to thank Karen for putting together materials. I didn't know materials could be put together without typos, since I usually do my own. So it was nice to see non-typoed materials, and I do thank you for putting those together. So I think I do have back-to-back cases here, but and it is bad faith, but you're going to see here that bad faith is relative, and that you can go to the well multiple times. And sometimes you can stay and sometimes you cannot. So we'll start with the good bad faith case. In other words, where it wasn't found in Warden. And here it's kind of nice to see Northern District, New York represented in a Chapter 12 case. But case number 1 was filed in January 2016. And the case was ultimately dismissed for failure to file and serve notice of confirmation hearing. So if you're looking at that like, oh gosh, the debtor really didn't do its job here. And that's why the first case was dismissed, but more on that later. Case number 2 was filed in June of 2016, just 5 months later. And this also was dismissed before confirmation. So if you were looking at just in a vacuum at those two findings, you're thinking, oh, we have got a serial filer here that has no intent of ever filing a plan. But wait, there's more. Case number 3 was filed in December of 2018. Here was dismissed by the trustee for failure to file a plan. Then we have the pandemic. So there's a brief pause in filings of bankruptcy for this debtor. Filing in February 22, they're back, filing their 4th bankruptcy case. So here the creditor files to dismiss the 4th case because of serial filings and that the debtor has no desire or ability to confirm a plan. The debtor countered by arguing they had made significant changes between the 3rd and 4th cases. Note that they didn't specifically mention the 1st and 2nd cases there. And I'll get to the reasons the debtor was able to show it. But the court says Chapter 11 cases and rulings aren't applicable to Chapter 12 because farmers have enjoyed a favored status under bankruptcy law. That's the ruling there. Take it how you can. But generally speaking, I will say farmers do better under Chapter 12 than perhaps their Chapter 11 counterparts do oftentimes. But there's 2 things that, at least under New York law, or applicable law, they had to prove two things to show that the case should be dismissed for serial filings or no ability to confirm a plan. One is an objective standard. The other is a subjective standard. First, that the creditor would have to prove that there's under the objective standard, a futility of reorganization, that there was no reasonable probability the debtor would emerge from bankruptcy. Next was a subjective standard, and that's no reasonable likelihood that the debtor intended to reorganize here. And this, again, the court looked at an amalgam of factors for good faith or opposite bad faith. But again, every case comes down to case specific. So in some of my cases, I've kind of eschewed some of these multi-factor tests because every case you look at, judges will pick and choose from the factors they like, and that the factors that don't apply, they'll say, but that doesn't matter here, or it doesn't weigh the thing. But understanding each judge is different, and you may have to apply your unwieldy 8 to 10 factor cases. But here the court looked at what had happened, and the debtor made very good arguments here. The creditor not so good. When they filed their first case, it was a bank loan. And then as the case was progressing, then they sold the loan. And the debtor and that new creditor, or I hate to say newco, kind of talked, and they thought, you know what, we can do this outside of bankruptcy. So that's why the debtor never filed and served notice of confirmation hearing. It was largely kind of an agreed consent to dismiss because they were going to work it out. Case number 2 filed in June. They also filed, but again, the creditor and the debtor were talking, discussing. Maybe the debtor was a bit hasty in filing because things weren't going well, but the new creditor again agreed that we can work this out, and we don't need bankruptcy. There's judges involved. There's trustees involved. Debtor and creditor can work it out much more smoothly than anything else. So that was kind of a consent to filing. So the debtor's like, we weren't abusing the bankruptcy process. We were just negotiating, and it seemed like bankruptcy wasn't the best option. Case number 3 was filed, and there was a lot of disputes. But ultimately, there was the pandemic involved. There was a lot of exigent circumstances. And after the case was dismissed, though, the debtor did significantly retool its operations. It really wasn't operating necessarily as managing. It did some other things. It was working other people's cattle, not necessarily its own. So it was kind of overseeing things. So a lot had happened in between 18 and then the 4th filing in 22. And the debtor was able to show through very good testimony. And as a note, testimony here was a former Chapter 12 trustee as well as Chapter 12 trustee consultants. So, I mean, the parties here really did use some pretty good experts in the ag field. And ultimately, the debtor was able to show that there was a probability that its retooled operations could emerge from Chapter 12. So the objective standard wasn't met for dismissal for bad faith, and that there was a reasonably high likelihood that the debtor did intend. It had changed its operations significantly, and that you shouldn't hold against it its previous cases because they were different circumstances. The first 2 were largely renegotiating with a new creditor. And then the third one was just, kind of chopped up to pandemic. Things were weird, and that the new and improved debtor had a chance. So here the court did not find that it was filed in bad faith because the objective and subjective standards were met, and the case was allowed to stay. So I don't want to say that the takeaway here is that 4 cases are okay. But if you have multiple filings, you have to have a good reason to be back. And the debtor here was able to show it. And the creditor wasn't really able to disprove any of the things because the projections for new debtor, 4th debtor, showed they probably could reorganize. So the debtor was rewarded for its testimony and efforts and was allowed to stay in bankruptcy. And I think I'm up next again, Rebecca, with the next one, Henry Watkins. Yes. So if 4 is okay, what happens if you file 7 cases? And that's our debtor here in Henry Watkins. They had filed 7 Chapter 12 cases between 2009 and 2022, proudly serving and trying to amp up the numbers for 21, 22 for the height of Chapter 12 filings in the United States. So, but here in the 7th case, Let me add too, in the 7 cases, I mean, it was a trek. They had 3 confirmed plans actually out of their 7, but later they defaulted. So they were trying in most of the cases. But here we are in the last case, the 7th case. And here the debtor, the court on its own is like, you know what? It had a hearing initially, order show cause why the case shouldn't be dismissed. But they did give the debtor an opportunity to put something together. So the court's like, go ahead and put a plan together and let's see if you can do it, rather than immediately dismissing with a 3-year bar, which is what the creditor asked for. So there were lots of issues here. Chapter 12 trustee questioned whether the debtor as currently existing even qualified for a Chapter 12. Chapter 12 trustee also pointed out that the debtor had been in bankruptcy for the 11 of the 13 last year, 11 of the 13 previous years, and made little progress towards reorganization. So basically the court said, and I'll use lack of a better term, but we're all friends here, put up or shut up. Let's see what you have. Give me your last best chance, the court said, to see what we can do. And the debtor did. The debtor put together a plan. It was a balloon payment. There were some issues there, but put together a plan. And then the creditor came back and said, Judge, they're arguing with our proof of claim, but long story short is, even if their plan's successful, they can't pay us off because the lump sum payment isn't enough to pay all claims in full. The debtor argued, but Judge, no, I'm arguing with the bank. I think their claim is invalid, and gave a couple of additional whys. But the court saw through this pretty quickly because long story short is there was $40,000 of a $2 million claim in dispute. And the bankruptcy court said, even if you win and I knock their claim down 40,000, you still can't pay the creditor in full. And therefore, because this was all in a show cause, found that the filing was in bad faith because the debtor could not successfully reorganize, even if the court was to confirm this last gasp for a Chapter 12 plan. So the court actually did dismiss for bad faith filing and barred the debtor for filing for 3 years. Now, this was a 23 case at a BAP where it was appealed. So we might be actually getting to the point where we're past their 3-year ban. So I don't know if the debtor will refile again or not. But it just goes to show you that if you filed that many times and the judge gives you one last time, make sure that at least on paper it works. Here it didn't even work on paper, and the court had little time after the show cause. But I think the amazing thing to me as a judge was that the judge was willing to give the debtor another shot after all of this time. And maybe there's just kinder, gentler people there, but I would think maybe after 6 times, a court would be a little a little tired of it. But the court did give them a chance and they failed. So this was bad faith. So the takeaway of these 2 cases is serial filings aren't great, but with good facts, you can overcome them. But if you're facing them and there is no chance, move early so that you can get rid of it rather than being stuck again. And if your debtor's counsel's on here, if you're on here, if you're taking multiple filings back to the well once again, make sure you have evidence that things are different, truly different this time, and B, if you do, that your plan works on paper, because obviously serial filings aren't necessarily forbidden, but they are suspect and will receive additional scrutiny. So if your case might not fly, you may not want to package it the same, or if you do, wait enough time so that you can create some evidence to show that this time, in fact, Judge, it will work, I promise, and that you can show it.
Thanks, Judge. And now for the rest of the time, you're gonna be tired of hearing from Karen and me. And we have about 15 minutes left, and we want to try to finish just a minute early if we can for questions, plus to give everyone a little bit of break if we can. So Karen and I are gonna kind of push through the rest of these cases quickly. So I'll turn it over to Karen.
The next case is Inri JC Farms LLC, and it deals with a creditor's request to file a late claim when it knew about the bankruptcy before the bar date, but wasn't sent formal notice of the deadline to file a proof of claim. This one is number 11 in your materials. As a quick overview, in this case, creditor Baker Implement Company sought to file an untimely claim for about $56,000 related to the sale of a drill planter to the debtor. The debtor listed the drill in Schedule AB, but had never paid for it. The debtor did not schedule a debt to Baker and didn't list Baker on the creditor matrix. Because of that, Baker didn't get the court's formal notice of the bar date. Several months after the bar date, the debtor filed an expedited motion to sell equipment, including the drill, at a public auction. But at the hearing on the motion, the debtor's counsel shared without explanation that the debtor no longer wanted to sell the drill. At a confirmation hearing a few weeks later, debtor's counsel explained that he recently learned the debtor had never paid for the drill and that the creditor had retaken possession of it at the auction site. The court clarified in the confirmation order that should Baker hold an allowed claim regarding the drill, that claim would be paid in full over 5 years, along with the other unsecured creditors. About a week after that, Baker filed a proof of claim and a motion to allow a late filed claim. The debtor objected. In that, the debtor argued that because Baker had actual knowledge of the bankruptcy, it should not be permitted to file a late claim. The parties stipulated that Baker did not get the formal notice of the bar date because it was left off the schedules and creditor matrix. They also agreed that the drill had been sold by the debtor at a different auction where the proceeds were paid to a different creditor. Generally, a creditor, for them to participate in the distributions in a Chapter 12, they have to file a proof of claim within 70 days of the petition date. Claims filed after that date aren't allowed, and the creditor doesn't get to share in the distributions. But there are exceptions to this. Those are found in Rule 3002C. Subparagraph C6 provides that on a creditor's motion, a court may extend the time to file a proof of claim for 60 days if it finds that notice was insufficient under the circumstances to give the creditor reasonable time to file a proof of claim. The creditor bears the burden of proof. Considering this question, the court found the language in 3002C6 to be ambiguous. It could be understood in two ways. Specifically, the court said that the notice referred to in the rule may be derived from a creditor's actual knowledge of the bankruptcy case or from formal notice of the bar date. Because it found the rule to be ambiguous, the court turned to the history of Rule 3002C6. And with that, I'll just quickly say, in reviewing the earlier versions of the rule, first in 2008, and then later an advisory committee comment in 2017, the court concluded that what was being referred to there was notice of the bar date. And considering that history, the court found that, again, the notice was referring to the bar date, not the actual knowledge of the bankruptcy case. So in this case, the court even assumed that Baker was aware of the bankruptcy in time to discover the bar date and file a proof of claim before the deadline, but the court found that knowledge to be immaterial. The notice that was relevant here was, again, notice of the time to file a proof of claim, that deadline, and not, again, awareness or knowledge of the actual bankruptcy.
Thanks, Karen. I'm up next, and I'm going to talk about the Lakeland Planting Company case, and this is a contempt case, a sanctions case against a creditor. And I'll go through it fairly quickly. This was a liquidating Chapter 12 plan. There was a truck that Ally Financial had a lien on. The truck was part of a motion and approved sale at a public auction. The court approved the sale. The sale happened. The truck sold, and Ally didn't respond or oppose the sale at all. The trustee informally requested the title from Ally, got no response. A motion for turnover was filed. Ally didn't respond. And while this was going on, at least the trustee, if not debtors counsel, was in touch with Ally's local counsel and eventually their general counsel. The court set a hearing on an order to show cause and sanctions against Ally, and they finally showed up. And all this happened over months. It took about 6 months from start to finish. And when Ally showed up, they turned over the title the day before the order to show cause hearing. They filed some conflicting affidavits, and the court wasn't really impressed at all with the excuses that Ally had. And they had a servicer. And even after they knew, the court found that Ally intentionally withheld this vehicle title because they wanted, more information. And because of the unnecessary delay to the administration of case and the time and expenses, the sanction ended up being $100 for 29 days to the trustee, and then the professionals, the debtors council, and others who were involved who'd spent time on the order to show on the turnover motion and everything that had to happen because Ally didn't respond. It's got to file fee applications and take care of this. And I know this is, as a trustee, something that we experience from time to time is just the non-response of some creditors. So this case does kind of lay out, okay, if you're not getting the response and you need it, might be a good guide for you to use to say, hey, what are the steps I need to do to get this in front of the court, to get the creditor to pay attention if you need to. And with that, I'll move it back to Karen to talk about the Osborne case.
I'll go through this one quickly. We did just want to make a mention of this. This is number 11 in your materials, and matter of Osborne is out of the Bankruptcy Court for the District of Nebraska. This one is related to the deadline to object to dischargeability, and unfortunately for creditors' counsel, it's also a cautionary tale about not waiting until the last minute. To quickly run through the timeline, the creditor had notice of the bankruptcy on May 8th. June 3rd was the last day to timely file a motion to extend the deadline to object to dischargeability. On that day, the counsel for the creditor reached out to debtors' counsel to request an extension at about 3:40 that afternoon. Debtors' counsel emailed a response a few minutes later agreeing and providing a template. After modifying the template, creditors' counsel returned it for a final review just before 5 o'clock. Unfortunately, then creditors' counsel ran into an ECF issue. The filing attorney's PACER account was not linked to the CM-ECF system, and creditors' counsel had asked the debtors' counsel if they would file it instead. They'd initially declined. Creditors' counsel sent several follow-up emails that night that went unanswered. And ultimately, long story short, the creditor missed the deadline. They filed their motion to extend a few days later. So the rules for the deadline to file the objection to dischargeability are in 4004A and 4007C. That deadline can be extended for cause as provided in 4004B and 4007C. But the motion to extend must be filed before the time for filing the complaint expires, and it can only be enlarged to the extent and under conditions that are stated in those rules. The court really showed no mercy here in this situation. They found the debtor wasn't the cause of the creditor's failure to timely file. The creditor had adequate notice, but just failed to act diligently to preserve its rights. For those reasons, the court declined to invoke equitable tolling, specifically saying that the creditor's counsel waited until the end of the business day on the last possible day, and it did so at its own peril. So one takeaway here is just to always budget time for the unexpected, and especially unexpected tech issues.
Yep, for sure. Thanks, Karen. I've got the next two cases, and these are regarding dismissal. The Welling case, that case, and it was a dismissal for payments, and the court ended up not dismissing the case. The debtor did miss a large fall payment, caused the creditor to file a motion to dismiss in the spring. And the debtor was working on a sale to a family member after the motion was filed, and the debtor responded. They had made a partial cure payment. Creditor, was insisting that the case be dismissed, and the court denied the motion a long way, saying that there's no bad faith, citing the partial cure payment, citing that the sale that would pay the creditor in full. I think that was important in this case. And saying that, my takeaway here is the debtor's trying. So the court is generally going to give the debtor who's trying a chance. And I think one of the things that was underlying the creditor's position in this case is that the property vested at confirmation, and there was an increase in value of this property. And so the court does say in the opinion that increase in value goes to the debtor. Creditor had been crammed down, and they wanted the case dismissed so that they could take advantage and kind of get out of the plan agreement that they had. The next case is also a dismissal case, Richardson. this case was dismissed by the court. The case was filed in March. The plan was due June 5th. There was no plan. The creditor again was the one who acted here. He filed the motion to dismiss when there's no plan. The debtors then 5 days later after the motion to dismiss was filed a perfunctory objection and a plan that the court found to be just a very inadequate. There were multiple objections to creditors for this plan. And the court looked at 1221 in this case, which gives a very strict deadline to file the chapter 12 plan. And while there is an ability to extend, the ability to extend the time to file a plan in chapter 12 is for circumstances for which debtors should not justly be held accountable. I think we're all familiar with that, and that is a high bar to overcome. And so the debtors actually ended up withdrawing the plan before the hearing, but they said, well, we're just going to try again. We filed the plan, we're going to try again. And the court said, no, that's not enough. The case is dismissed for bad faith and for failure to timely file the plan. And we have 4 minutes left. So Karen, can you do the next case in about a minute?
Yes, this is Inri DLB2 LLC. I would just recommend reading this one. I found it interesting. But essentially the debtor here, which is a limited liability company created by an individual named Doug Bell. He had created it, it appeared, for the purpose of putting just one piece of property, the Heather Lane property, in this LLC. That property was intended for a site for him to purchase and restore farm equipment that he would fix up and resell. He made several representations about this LLC, specifically to the Iowa Secretary of State, twice saying that it was basically not, the land was not involved in agriculture. He made several representations to a creditor, Mona Management, that he was requesting a loan from, that he was not involved in farming. They did their due diligence trying to learn more about his business, found no evidence he was involved in farming. Once they made the loan to him, things went south quickly. He only made one payment before he defaulted in the loan, and they moved to foreclose. That's when the debtor then filed for Chapter 12 bankruptcy. So that was a surprise to the creditor, who had all these representations. He was not involved in farming. The court goes through some interesting evidence in this case with how they're making the determination, but ultimately finding this LLC was never involved in farming. He had asserted he was involved with raising livestock. They found that not to be the case. They also just found on its face his schedules failed to meet the definitions failed to meet the asset or debt standards provided in sections 101(18)(b) for, again, qualifying for a Chapter 12 debtor. And they also found, just based on, again, the representations made to the creditor that did not bear out to be the case, that the creditor had also met its burden to establish fraud under section 1208D. Ultimately, they ended up converting the case, to a Chapter 7, which is what the creditor was requesting. But it is an interesting case. I recommend checking it out.
Thanks. I've got the last two cases, and I'll get through them very quickly. The eligibility case here, the Vera T. Welty Testamentary Trust. The headline here is that the court found that no trust other than a business trust is eligible to be a Chapter 12 debtor. And the court goes through a lot of definitions in 101, including the family farmer, that could include a corporation. A corporation in 101(9)(AV includes a business trust. And then definitionally, what is a business trust? And there's an 8th Circuit 6-part test that the court goes through. And the court found that this case didn't meet those factors. And so the case was dismissed. If you have a case like this where you get a trust, this is a good one to just put a star by and make sure you understand that. I'll note this was a 2019 case, and the dismissal didn't happen until 2024 because there was a bunch of appeals involved. And then our last case, just really quickly, is a subchapter 5 case. But the thing that made us put this in here is that the court went through a comparison of the disposable income test between Chapter 12 and Chapter 13 and subchapter 5. And while they found the disposable income test really similar, the difference is that sub 5 has no mechanism for what this court called a true up, that the debtor couldn't, what the creditor wanted, it was actually the sub 5 trustee wanted a provision in the plan that the debtor had to true up and say, okay, here's my projected disposable income, and at certain points along the way, say, here was my actual income, and true that up and maybe pay more to creditors. And the court said, you can't do it in sub 5. And one of the reasons, the kind of primary reason, other than I think the court was skeptical of this anyway, but only the debtor can modify a sub 5 plan. Unlike in chapters 12 and trustee, where it could be the debtor, the trustee, or an unsecured creditor can modify the plan. So that's another case to look at if you're looking for disposable income issues.